So if viewer asks me, what happens when you decide that you want to fire your lawyer? What do you do? Well, in just a moment, I'll have an answer for that. Firing an attorney is a pretty important step. It's a big step and one you should consider carefully. But lawyers are just like electricians and plumbers. You can hire them and fire them at will. The only difference is that a lawyer has a lien on your recovery if you are a plaintiff. Now, if you're a defendant, in most cases, the defense attorneys don't have liens. But if you hire an attorney to represent you in an automobile accident case, for example, and you have $20,000 or $30,000 worth of medical bills that you wish to recover, right? Then he has a lien on any recovery that you make, even if you discharge him. However, if you retain him and you go through the case and you collect based on his contract, if it's a contingent fee contract, his recovery is limited to whatever the contingent fee is. Right? It can't be any more than that. That's how much it is. Now let's suppose that you go and you fire your attorney midway because he just isn't getting anything done. And you hire a different attorney, and that attorney is able to get the case settled and get you some amount of money. Well, you're still going to have to pay the first attorney under the doctrine of quantum merit, which essentially means as much as it's worth. In other words, you're going to have to pay the lawyer, the first lawyer, for the value of his services up to the point in time where you terminated him. If he drafted the complaint or the petition, if he answered the discovery, all of those things are services that were provided to you that you should have to pay him for. And of course, he will usually work that out with your current attorney once the case has been settled. Hey guys, if you like this so far, I would appreciate it if you would smash the like button there on the YouTube console. And if you haven't already, subscribe to our channel. Thanks. Now here's another issue, and that issue is, how do you go about getting another attorney? Well, the law says that you can't engage another attorney until you have fired the first one. So you have to be a little bit careful in that another attorney may not want to take on a case that some other lawyer has had. And there are a couple of really good reasons why. For example, I will very rarely get involved in a case that another attorney has taken down the road. And the reason I don't do that is because if they've made an error in the preparation of the case and I take over the case, it becomes an error I have to deal with. And I don't want my client upset with me because he can't recover because of something the first attorney did, because people tend to be mad at the lawyer that's in front of them, not the lawyer that screwed up the case. So a lot of times I won't take a case that has been, that another attorney has been fired from. But a lot of times other lawyers will take those cases because they see the value in them and the merit in them. And in that situation, you still have to fire the first attorney. And only then will that other attorney talk to you. If you call up an attorney and say, hey, I've had a motorcycle accident and I want to get paid, and they talk to you a little bit and they say, well, what do I do about my attorney that I have now? That lawyer is going to stop talking to you. He's going to tell you that he can't tell you anymore. He can't deal with you anymore. Because you have an attorney, and if you decide you don't want that attorney, you can call back. But you have to fire that attorney first, because otherwise the first attorney gets the impression that the second attorney reached over him to steal that case. And that's not a good look. And the law frowns on that. There are ethical rules that prevent lawyers from doing that. So that's why you have to fire your attorney first. And then you have to go out and search for another attorney. And of course, that also causes problems with the courts in that The lawyer that you fired now has to withdraw, and the court may not let them withdraw until such time as a new attorney enters his appearance on your behalf. So there's all kinds of things that come up in the course of these situations where you decide to change lawyers. This is one reason why I think it's very important that you evaluate your lawyer before you ever sign on the dotted line. Find out whether he's tried this kind of case, what his experiences have been. Does he know the defendant? Does he have any conflicts with the defendant? Tell them who the witnesses are. Does he have any conflicts with any of those witnesses? Because you don't want to be in a situation where 10 months down the road, this attorney comes to you and says, hey, I've developed a conflict of interest. I can no longer represent you. Because now you're having to find another attorney in the middle of the case, which is not a good situation for you. So always make sure that you've hired the right attorney first, and that will limit the damage that can be done from having to change attorneys, because hopefully if you've hired the right guy, you won't want to or need to change attorneys later on. So I hope this has been helpful or useful. If it has, please smash that like button for me and click on the notification bell, subscribe to the channel. Be happy to let you know anytime we release a video on this channel. Thank you so much for watching. Have a great day, and we'll catch you next time. Thanks.